Hi, my name is Lonnie Johnson, and I'd like to talk about a case that I've been working on for some time involving Bishop Rufus Kiles. Bishop Rufus Kiles is a Texas bishop based in Houston, Texas. Back in November of 2013, there was a situation where he traveled from Beaumont, Texas to the Magnolia Springs area with an 18-year-old college student, freshman, and to get his wife's car inspected. And the evidence in the trial that came out in the trial was that he went to get his car inspected. He left there and took her by the house where he grew up to show her that house. According to him, he pulled up, and this is in his deposition testimony as well as trial testimony. He pulled up, he left her in the car. He said he left the car running, and he just went inside to check to see if there was any leaks or break-ins. As you walk inside the house, the first thing inside the door is a room where there's a bed there, no other furniture. He said he walked through the house and he came back. It took him less than 5 minutes. And when he got back to the front door, this young lady was inside the house standing at the front door. That's his version. He said, at that point, I left and we went and drove back to Beaumont. I dropped her back in Beaumont. Her version is quite different. She said, we got to the house. He turned off the car, got out, and he asked me to come in. I said, no, I'm fine. He kept persisting, and she said, okay, fine, I'll come in. She went inside the house. She said he gave her a tour of the house, including he went and she did a written statement shortly after the incident. And she said in her written statement that he took me in the next room. There was a kitchen there. He opened the refrigerator, and there was 2 cases of soda in the refrigerator. That he offered her a soda. She said, no, I don't want one. He took her back and toured the house. He showed her in one room there was a gun holster on the back rail of the bedpost. There was a mattress that had a stain on it. She described in great detail the house. She said they came back to the front of the house. As by the door, she thought they were going to leave, and he sat down on the bed. Asked her to sit down beside him, and she declined. And finally, she said, okay, and she sat down away from him for a bit. He scooted over, according to her testimony, according to her affidavits. He scooted over, put his arms around her, pulled her down on the bed, and proceeded to touch her and put his hands and head in places where he should not have had him, in her private areas. He became startled when a car passed by. She was able to get up and she ran out, and they drove back to Beaumont. Now, you say, well, how do you know she's telling the truth? Or what version, why would you believe that version over his version? Well, there are a number of things, but one of the things that was most alarming, ignoring his past. This is not the first time he's had this type of allegation against him. But one of the issues that really impressed me was when I talked to him and I took his deposition and I asked him, I said, what time did you arrive? Just trying to get the timeline together. So what time did you arrive, get your car inspected? He said between 2:30, 3 o'clock. Okay. And how long did it take you to get to the place where from the car inspection to the house? Less than 10 minutes. How long were you at the house? 5 minutes, no more than 5 minutes. How long did it take you to get back to Beaumont? Just over an hour and 6 minutes. What time did you arrive back in Beaumont? He said between 4 and 4:30. She had testified they arrived back in Beaumont between 4 and 4:30. When I look at a receipt from where he had his car inspected, it said, and I confronted with that at trial, he said the receipt had 1:39 as the time the car was done inspected. So I said, well, Bishop, if the car was inspected at 1:39, it took you 10 minutes to drive to the house. That's 1:49. 5 minutes in the house, that's 1:54, and an hour and 6 minutes to drive back to Beaumont. That would put you back at Beaumont at 3 o'clock. You said you got back between 4 and 4:30. What happened to the missing hour to hour and a half? He said, I have no explanation for that. I don't know what happened. There was another young lady that said she went to that same house with him, a house that only he has a key to. Only he said he's the only person that goes there. It's been vacant since his parents died back in the 80s. And so this other young lady said, I went there when I was 18, and I actually had sex with him. And I asked him, did you ever take her to the house? He said, no. Have you ever been around her where in a room where you didn't have a shirt on? He said, no. Have you ever been around her when you were naked? No. I said, well, that would be conduct unbecoming a bishop, wouldn't it? He said, yes, but I didn't do it. I said, okay, well, can you explain, if you've never been around her without your shirt on, can you explain how it is that she knows that you have a mole on your chest? I don't know how she knows that. Maybe it's sometime like a show through my shirt or something, and she hadn't known that. Okay, fine. If you never, and I asked him this question, I said, if you've never been around her naked, how is it she knows you're not circumcised? I don't know how she knows that. With all these facts together, we took this case to trial before the Board of Bishops. Every bishop in the Church of God in Christ is allowed to vote, and they did the right thing. They listened to the evidence, and they found him guilty. And not only did they find him guilty, from the punishment phase, they recommended to the General Board of the Church of God in Christ that he be removed from the office of bishop of the Church of God in Christ. And as such, the General Board acted upon that recommendation. But unfortunately, within the Church of God in Christ, there's a judiciary board that was voted in some years ago. And that board serves as the Supreme Court of the Church of God in Christ. Well, they heard oral arguments on that case in April. Before the argument started, we objected to the Chief Justice being included, because a lawyer for Bishop Kyles that was sitting there in the argument was also a lawyer for the Chief Justice. And I said to them, how would you feel if you went to the Supreme Court of the United States and the lawyer on the other side represented Chief Justice? How is that viewed as being fair? You have to make sure that whatever your decision, it's viewed as being proper. They ignored that objection, and the Chief Justice participated in the trial, in the argument. Well, they came out and they overturned the verdict completely. It is the most ridiculous appellate opinion I've ever seen in my life. They do things that no appellate court would do. Not only do they consider issues that were never raised at trial, one of the issues they offer for overturning the verdict is that the trial court didn't say how many people voted in each category, guilty or innocent. I explained to them that in a regular court, a federal court, the trial court never puts out what the actual vote was. You get a jury form. That form goes back with the jury. When the jury has completed their work, the jury foreman will sign that saying, this is our verdict. That's a regular trial. In this case, Bishop Sheard, who served as his chief bishop, and he signed an order saying this vote represents a majority of the bishops present and voting. That's all that was required. In a regular court, if the lawyer is concerned as to whether that was really the vote of the court, of the jury, then that lawyer has a right to say, I'd like to poll the jury. Well, in this case, although they never requested to poll the jury, they filed an appeal saying we didn't have a right to poll the jury. We were not allowed to poll the jury. It wasn't that they weren't allowed to, they just chose not to. They never thought about it, or they did chose not to do it. Whichever way, they didn't ask to poll the jury, and months later they asked what the jury verdict was. There is no court in the country other than this kangaroo court called in the Church of God in Christ, the Judiciary Board, that would consider this. They go a step further. They raise objections that were not even objected to in court. They objected to the opening statement, and they acknowledge it's rare, if ever, that a case is overturned based on comments made in opening statement. But the comments they concern themselves with in opening statement, there was never an objection during the time of trial. Now, if there's an objection during opening statement, the typical thing to do is the judge will say to the jury, disregard that, especially in this case, they're saying it was just the objection that they raised, they being the Judiciary Board. They said in opening statement, there was a misstatement of what the burden of proof was. In any court, if that were happening and there was an objection made at trial, it would be cured, because the judge would say, statement of counsel does not represent the law. I will tell you what the law is. ignore anything he says or she says about the law. That's how that would be handled. There was no objection made at trial. It's just Judiciary Board, they decided to impose their own objection. And by the way, one of the things that's most disturbing, why I think the Church of God in Christ has to do something different. They have 9 people serving as as judges or justices. They call themselves justices. They fashion themselves as a Supreme Court. But of the 9, only 3 of them have legal training. You've got 6 people sitting up there who have no idea what the law is. They've never practiced law. They are not lawyers, nor are they judges. Yet they're called as the Supreme Court to rule on legal issues. It's ridiculous. And so my point at this point is to say to the Church of God in Christ, you have to do something different. You have to get people who know the law, number one. And you have to get people who recognize conflict. And if there's a conflict, you have to step down. There's no way that Chief Justice Jackson should be sitting there with a lawyer on the other side who represented him, and he's going to still say, I'm going to be fair and impartial in this case. They didn't stop there. There were a number of things they did. And I'll raise one last one because they all are equally, they had 6 points and they're all equally as ridiculous. There was one point where they said there was certain evidence of a past trial involving Bishop Kyles that that evidence should not have been admitted. Well, the problem with that is both sides stipulated to that evidence. Bishop Kyles' lawyer agreed that that evidence was admissible. They agreed to have it admitted, and at no time during the trial did they object to the admission of that evidence, because they had already pre-trial, they had already stipulated that this is evidence, it's coming in, we have no objection to it. Once you stipulate the evidence, it comes in. The court has no authority to say to the parties, no, you can't agree to have this evidence come in. Both sides agreed, said, yes, the evidence come in, no objection to it when it came in, and yet the Judiciary Board said, in our infinite wisdom, we believe that evidence should not have come in. It's a kangaroo court. So Church of God in Christ has to do one thing. First, they need to get people on the Judiciary Board who understands the law. I feel, it bothers me that people people serve there who don't understand the law. But what's even more pathetic, what I find even more offensive and pathetic is there are 3 people on there who are lawyers. There is one woman on there who is a woman on there who is a judge. And I think it is simply pathetic that she would allow this type of verdict to come forth. If she didn't vote for it, she should have been out there writing a dissent. There is no way that a judge, and especially a woman that would see this happen, see this evidence related to an 18-year-old girl, would sit there and say, I'm going to let him off. And they came back and said, not only do we find that we're going to reverse the decision, we believe that you should not have had him step down as pastor. So that decision, that's void too. Now, I'm hoping the Church of God in Christ will think twice before they let that happen. Because if he should come back to the pulpit and decide he's going to do the same thing again, woe be unto the Church of God in Christ when the next time it comes out. Because then they're looking at civil cases and looking at actual knowledge. They're looking at knowledge of what he's doing. And people say, well, what do you have against Bishop Kyles? I have nothing against Bishop Kyles. My problem is with his actions. And as long as you allow people to continue to do the same thing over and over, then they're not going to change. And if you hold them accountable, they will realize I can't continue to do this. So that's my mission now, is to get this as widespread as possible, to say, Church of God in Christ, you've got to do different. You got to do some things differently. You got to clean up your act. And I'm not faulting the church per se. I'm saying the church has made some mistakes. They need to correct those mistakes. Put people on the Judiciary Board that should be there and continue. The Board of Bishops, I applaud them for their effort. They did the right thing. They listened to the evidence. It was a 3-day trial. They sat there and they listened to all the evidence, painstaking evidence. No one wants to sit there and listen to whether someone was circumcised or not. But they sat and listened to all the evidence, and they made a decision. They did the right thing. The General Board of the Church of God in Christ, they did the right thing. They took the recommendation and they acted upon it. There are 9 people who has caused this problem by reversing it. And I say we have to fix that. Thank you.